Welcome. This video will accompany the notes covering Chapter 18, Common Equity, in Intermediate Accounting 2 at Faulkner University. A corporation is an artificial entity existing only in contemplation of the law, existing separately from its owners. Corporations in the U.S. are created and organized under the laws of a particular state, and those laws do vary somewhat. Delaware is a very popular state in which to incorporate because it's got relatively low fees for incorporation and also for renewal of that status in the state, and also relatively low taxes on the corporations that are domiciled in Delaware. Features of the corporate form include separate legal entity from its owners, managers, employees, or anyone else. You know, for accounting purposes, really any entity can be separate. If you maintain separate records, which of course is what you're supposed to do, it's the economic entity assumption that's one of our, underlying assumptions in the GAAP conceptual framework. But if you are, let's say, a sole proprietor, or you're a member of a partnership, let's say a general partner in a limited partnership, or simply a regular partner in a partnership, then you will certainly have your accounting records will treat that enterprise as if it's a separate entity altogether, but legally there is no distinction between the assets, liabilities, the operations of the individual, the owners, and the operation and the assets and liabilities of that business itself. The corporation allows that separation. And one of the benefits, key benefits to that is, number two, limited liability of its owners. You can lose every dime that you have invested in a corporation, but you can't lose any more than that. The notion of limited liability means that the obligations or the liabilities of the business are those of the business and not of its owners. And so you can lose everything you have invested, but you can't lose more than that. They cannot come against personal assets. Once again, that's a distinction that's really important. If, for instance, you want to buy shares in Google, but you're not apprised of or involved in day-to-day operations, and if it were possible for you to, let's say, put at risk your own personal assets by virtue of something that Google management did, you probably would be very reluctant to invest in the first place. So that limited liability allows people to make a stake in a business where they really don't have a knowledge of what's going on a day-to-day basis, without risking more than the amount that they have invested. So you can lose 100% of your investment in a given corporation, but you can't lose more than that. Transferability of ownership, that's a very important characteristic too, because essentially, you probably understand this, if a sole proprietor passes away or leaves the business for some reason, can't function, then that sole proprietorship is no more. That entity is basically dissolved. And the same thing goes for a partnership. That is, if one of the partners leaves because of incapacity, death, retirement, whatever it might be, that can really be a big burden on a partnership, because the articles of partnership may require that, in fact, that partner be cashed out. That is, that they be given cash equal to the value of their investment in the business, and that can result in the dissolution of the partnership, and in fact, the cessation of that partnership's activities, because they have to pay out a great deal to the departing partner. Unlimited life, regardless of changes in the ownership. You can buy and sell shares, for instance, of a publicly traded corporation. Matter of fact, millions of shares change hands every day for many large corporations, and yet that doesn't affect the operation of the business at all. Number 5, no active involvement of the owners. Well, of course, that's not necessarily the case. You could have a corporation where, in fact, the owners and the managers are the same people. But by and large, certainly when we think of publicly traded companies, large corporations, even if the managers, say top management, have some ownership, it's usually going to be a very small percentage of the ownership of the company. It may be a very substantial percentage of the individual officer's assets, but still may not, probably would have very limited let's say, voting influence as a result of their ownership itself. Ease of raising capital because of all these other features: limited legal liability, easy transferability of ownership, unlimited life, and that there's not a requirement in general that to be an owner of a corporation that you also have to be involved in activities. That makes it easier for people to buy and sell their securities and more inclined to invest in the first place. Stockholders generally have these rights: to vote at stockholder meetings. Even if you own one share, of course that means you don't have much voting power, but you are still going to be invited and you're going to be welcome at the stockholder meetings as long as you're a stockholder. Stockholder meetings for corporations are required in general annually, depends on the state itself. You also have the right to sell your shares, that is, to get out from under the investment. One of the features, of course, of common stock is that it has infinite life or unlimited life. So if you buy some shares in, let's say, Nike, and then you decide you want to get out from under that investment, then you don't go back to the company and ask them to buy back your investment or to pay you the amount you've invested. You sell those shares to someone else. To purchase any additional shares in proportion to their ownership interest, the preemptive right. So if you own, let's say, 5% of a corporation, and that corporation decides to issue additional shares, you have what is more or less a right of first refusal to buy 5% of those of that new issue. In other words, the preemptive right allows you to maintain the proportional ownership in the business, but of course that means that you would have to pony up the money to buy those extra shares, and so it's not a given that you can simply maintain your ownership. You get the right, but you still have to come up with the money to buy those additional shares. Number 4, to share any distributions of profits in proportion to their ownership interest. And of course, these distributions of profits we know better as dividends. And number 5, to share any distributions of assets in proportion to their ownership interest should the firm liquidate. Typically, that's going to happen when a company is on the ropes financially and basically it's no longer a viable business entity. And so it closes down, and the process would be, of course, to settle its debts as it goes, as it liquidates assets to settle its debts, and anything left over then would be divided up proportionally among the common stockholders based on their proportionate interest. We all know the old saying, it takes money to make money, and a corporation begins activities by issuing shares of stock. You really don't have any ownership for the corporation in one sense until their stock has been issued. A corporation must receive permission to issue stock from its state of incorporation. Again, what you're doing, for instance, in the state of Alabama, you would get an attorney, or you would go to a website like LegalZoom.com, and for a few $100s, or if you go to an attorney for a few $1,000s, just depending on the nature of the business, you will apply to the state to be recognized as a corporation within that state. And the state, of course, is going to have to know your activities, because if it sanctions that you're in corporation, it has to be something, for instance, that's legal. You're also going to have to provide information about what line of business you're going to be into, go into, who the major players are, that is the initial stockholders, and how many shares you're going to issue, and that sort of thing. And depends on the state what you have to provide to them. There are three classes of shares and when a company gets the approval from the state to incorporate and to issue shares, we refer to those shares as authorized. That is, the state of incorporation has authorized the corporation to issue a certain number of shares. As we'll see later on, it's often many states will require that they identify a par value for those shares, which doesn't mean a lot, but we'll talk about that later. The next class or category of shares is those that are issued. Issued represents the number of shares that have actually been sold to the public. And then finally, those that are outstanding, the number of shares in the hands of shareholders. And so a company, for instance, might apply and obtain approval to issue up to 1 million shares of common stock at, say, a $5 par value. So that company would then have, let's say, 1 million shares of stock at $5 par value. Now, that is, again, a number that limits the amount of shares the company can issue. The state has authorized it to issue as many as 1 million shares, no more than that. And so then the company would actually sell those shares to stockholders or prospective stockholders, and those shares would be regarded as issued. And those shares that have been issued are also outstanding. If they're in the hands of shareholders, they're referred to as outstanding. You're going to have a larger number, of course, of shares that are authorized that have been issued, and very often the number of shares issued and outstanding may be the same, but the number of shares outstanding could be less than the number issued if the company has bought back certain number of shares and that they have issued. More about these later on. As we'll soon see, there are some shares that have been issued but are not currently outstanding because the corporation has repurchased them. We refer to that as treasury stock or treasury shares. Here's some other terms to be familiar with that we'll use in the as we look at the transactions in just a few minutes. Par value represents an amount assigned by the corporation in its charter. It really only has accounting significance, and many states, in fact, have done away with that and allowed corporations to issue what's called no-par stock. Alabama is one of those states that allows companies to issue no-par stock. Market value is the actual worth of those shares of stock as determined by the market. The board of directors can't vote and decide what their market value is. That's really determined by individual shareholders acting in their own best interest through the market. The stated value is really just another term for par value. No par stock is stock issued with no value assigned by the corporate charter. We'll look in turn, discuss how each of these values comes into play when it comes to issuing stock. Well, let's stop here, and I'll stop this video and start another one so that we can begin kind of afresh and look at common stock transactions.